Good morning and welcome to the Senate Committee on Commerce and Labor. I think it's just us and Finance meeting this morning, so a busy morning for us and then a very busy day on the floor, and we thank all of you for being here with us today. Would the Secretary please call the roll?
Senator Daley? Here. Senator Ellison? Present. Senator Flores? Senator Lang? Senator Rogish? Here. Senator Scheibel? Here. Senator Steinbeck? Here. Chair Pizzino?
Present. Thank you so much. And please mark Senator Flores present when he arrives. Welcome to the members of our audience here in Carson City. I don't see anyone in Las Vegas, though they may be joining us in a little while, and anyone who's joining us online. Before we begin, I'd like to make just a few housekeeping reminders. We've been away for a little while, so welcome back to everyone. Please do silence all of your electronic devices while in the committee room. Members of the public may provide testimony in various ways, all of which are listed on the agenda. You may also submit public comment in writing, either in addition to testifying or in the place of testifying. And if you wish to testify in person, please do sign in at the table by the door and leave a business card with our wonderful committee secretary. When testifying in person, please turn the microphones on to speak and off to listen, as we have those that are following along online. Please also state and spell your name for the record. Anyone who'd like to receive electronic notifications of scheduled bills and access to the committee's meeting materials may do so by signing up on Nellis on the legislative website. Please note that committee members will be using their laptops to view handouts as well as any other exhibits, so please don't view this as a sign of disrespect or inattention. And with that, we are going to move to our first agenda item of the day, which is Assembly Bill number 12, revising requirements for obtaining judicial review of a decision of the Board of Review concerning a claim for unemployment benefits. And we welcome our friends from Dieter.
Good morning, Madam Chair, committee members. For the record, Chris Sewell, Director of the Department of Employment Training and Rehabilitation, also known as Dieter. This morning, I know that we're starting with AB 12. We also have AB 21. And for ease, we have both bills in one packet, a presentation, so we will actually stop in between the two bills. But it's so that way you're not actually having to go into a different PowerPoint presentations, just so we can go a little bit quicker for you. Also, we have page numbers in the upper right corner if there are questions concerning the PowerPoint that you may have. AB 12 briefly is concerning judicial review of our cases, and I am not an attorney, so I am going to pass this along to an attorney that works as my deputy director, Troy Jordan, who will explain the bill and answer any questions that you may have. Thank you very much.
Thank you, Madam Chairman. For the record, Troy Jordan, Deputy Director of Dieter. I first wanted to thank the committee for the accommodation. I know originally we were requested to do Friday, but since we had budget closing in finance that day, I appreciate the accommodation of moving it today, because I know you were all on a deadline on Tuesday, I believe. As the director said, prior to me becoming deputy director, I was the senior legal counsel to the Employment Security Division, so I am the one carrying the water on this bill, so to speak, because I lived through most of what you're going to hear and was actively involved in some of the cases and the changing of statutes originally. This bill deals directly with NRS 612-530 subsection 2. And what we're doing, and I want to make this clear because this is one of the questions I got on the assembly side, is we are not changing any laws. We are codifying what the judiciary has ruled with regard to this statute. These concepts in the law exist regardless of whether it's in the statute or not, but the reason we brought this bill is because I felt as a member of the bar for the last 21 years that the more information that you can get, both our claimants, the judges, and the attorneys working these cases, which sometimes there are very few, the better it is that they will not violate these provisions because they are quite harsh. Anybody who's done administrative law, and I know I've got 3 attorneys on this panel today, will tell you that these deadlines are very strict and they're very harsh. And that's a very big thing when you are trying to seek unemployment benefits, because when it gets to this point, our claimants, which is the official name we use for people that have applied for unemployment, our businesses who may be appealing, or the attorneys who in many cases are representing these people pro bono this is the last stop. They're either going to get a reversal of a previous denial by a court, or they will not get unemployment. So it is very important that their due process is protected. It is very important that everybody knows the rules of the game so nobody makes a mistake. Now on slides 4 and 5, and I won't bore you with all of it, we have a background on unemployment for those of you that aren't familiar. I want to emphasize the last paragraph on page 4, that is a strict eligibility program, and it's not a needs-based program, and they must be unemployed at no fault of their own, able and available to work, search for work, and report any income that they do have if they're partially employed. The fifth one is where we start what is now this bill. Concepts related to unemployment in the law, specifically Kane, that says these benefits are not inherent rights, but they are product of statute. Therefore, the courts or the legislature can lay down any reasonable non-discriminatory regulation to this program that they see fit. It's been done numerous times, numerous cases, and statutes. Slide, please. Where this bill came into effect is the cross-match between NRS 233B-020 and NRS 612-530. NRS 233B-020 is the Administrative Procedures Act service provision. 612-530 is the service provision in the unemployment statute. Now it started, first the concept being in 233B, as a general rule, the general provisions only prevail if the specific chapter to the administrative function is not contrary, meaning if 612 is different from 233B, 612 controls because it's a more specific statute to that particular benefit, license, whatever the administrative procedure is looking at. In our case, what happened was in 2012, slide please, there was a case of Washoe County versus Otto. What occurred in that case is one of the attorneys for Washoe County failed to name all of the parties in a lawsuit in an Administrative Procedures Act action. The Nevada Supreme Court ruled that all of the provisions of that particular statute were mandatory and jurisdictional, including subsection 5, which was the service provision, and basically said if you violate these provisions, the court lacks jurisdiction and your case is then over. That held until 2019, when, you guessed it, an unemployment case was brought. And how the genesis of that case came before us is SPAR, who is not a person, SPAR is a corporation, two of their attorneys out of Minnesota frankly made a mistake. They did not look at the service provisions in the Administrative Procedures Act, they looked at the rules of civil procedure. They served us late. Our legal department moved to dismiss. It was granted at the district court level. They appealed to the Nevada Supreme Court. The Nevada Supreme Court looked at the specific provision in number 5 in 233B and gave the following guidance. Because there was a good cause provision that allowed an excusal of that, and our statute in 612 was silent on the amount of time you needed to serve, that 233B at that time controlled, and that there was good cause to excuse, there was the ability to excuse failure to serve. To say this sent shockwaves through the administrative law crowd was is an understatement, because until that point, everybody thought it was mandatory and jurisdictional. In response to SPAR, during the 32nd special session to this legislature, Dieter amended its own statute in 612 by adding the 45-day provision. Since then, there have been numerous attempts to clarify that statute that have come through, specifically Chopra in 2021. The Honorable B.D. Yeager down in the 8th Judicial District agreed with Dieter that by amending our statute, it became mandatory and jurisdictional again. That was upheld again in Noakley. And then a different provision of 612-530 was upheld, stating that this is so mandatory and jurisdictional that even the mailbox rule doesn't apply in the Joran matter, which was adjudicated in 2023. Our part in bringing this bill, and slide please, what I call the solution is, if these laws are going to be on the books anyway, and we know that an overwhelming majority of the people that come before this tribunal are either A, unrepresented, B, most likely not legally trained, C, pro bono attorneys who likely are unfamiliar with unemployment laws, the best thing we can do for them is to clarify in the statute the best we can and get all the information out there so they don't have to go searching for it. So what we did was we added a subsection 3 to NRS 612-530, which I can go through, which basically says, the requirements is set forth in subsection 2 that a petition must be served upon the administrator or upon such person as the administrator may designate within 45 days after the commencement of the action, must be strictly complied with and may not be excused by the court. Failure to comply with that requirement deprives the court of jurisdiction over the action. This is nearly the exact language from Noakley, but it also takes a sentence from Chopra and Joran. But in Noakley in particular, the Supreme Court found that the discretion indicated in the section's requirements in 233B 130 subsection 5 is not present in NRS 612. Therefore, the 45-day service period, a court can only conclude that the ability to extend or toll the statute does not exist since 2020. Given that the language suggests no discretion to extend the service period, that we must follow SPAR and conclude that the 45-day provision is mandatory and must be strictly enforced. All we're basically doing is putting Noakley into statute. And as I said before, with the amount of untrained people, the amount of unrepresented people that come in, we felt it was the best thing to do so that when they read the statute, they knew immediately, above all else, we have to serve this in 45 days. And with that, I will take any questions.
Senator Scheibel.
Thank you, Chair. So I'm sorry, I'm confused here because I'm looking at NRS 612.530 and subsection 3 does have a 45-day notice and service requirement. I'm guessing that's for a different filing than what you're talking about, but it wasn't clear to me in your presentation what the other filing is.
We're expanding on the 45, Troy Jordan for the record. We're expanding on the 45-day requirement, and this is, I'm sorry I confused you. Basically, back in 2019, that 45-day provision wasn't in there. That came in 2020. And we're trying to make it clear to everybody reading that statute that the court has ruled, since we've put it back in 2020, that it is mandatory and jurisdictional and cannot be excused. Because that's what Chopra, Noakley, and Joran have said. And our thing is in serving the client, they need to know that up front so they get their service done as quickly as possible. Because if they don't meet that 45-day deadline, the court will dismiss their action due to want of jurisdiction. We're literally just codifying the case law in this matter into the statute in subsection 3. The 45 days has been there since 2020. It's just not this explicit.
May I have a brief follow-up? I get that, and I appreciate that that is the current case law. So what was the thought behind codifying the current case law instead of making a change to policy and allowing for that 45 days to be excused for good cause or with, judicial permission?
One, because it had been the law for 7 years. Troy Jordan for the record again. One, that it had been the law for 7 years, but the other being it stopped the endless litigation There was one excuse during the interim period between SPAR and the amendment in 2020 that was 210 days past the deadline. We just felt that keeping that deadline was there, and the other thing was that was the original law. And we felt that if we were going to have that deadline and the courts were going to uphold that deadline, they needed to be aware of it.
Okay, that makes a lot of sense to me. So thank you so much for clarifying.
Vice Chair Daley.
Thank you, Madam Chair, and similar questions to my colleague from District 9. Who are the parties on these things? Is it always the administrator against some person filing for unemployment, or are the parties sometimes a corporation, not the administrator?
The administrator is always, excuse me, Troy Jordan for the record. I've violated that 3 times this morning, and I apologize. Troy Jordan for the record. There are actually 3 parties to every unemployment claim. That is the administrator, the employer, and the claimant. Now, I will also tell you that businesses have routinely violated the 45-day rule as well and gotten their appeals dismissed. It doesn't happen as often, but it has happened. I was the senior legal counsel, as you know, for roughly 4 years, and I saw it happen at least a handful to 2 handfuls of times where the businesses missed the deadline as well. So it does help the businesses as well. But mainly, at the end of the day, in the final analysis, it is either, I would say, in 90+% of our cases, an unrepresented person or an attorney that usually is taking the case pro bono because fees are not currently allowed. And these are not profitable cases, shall we say. They're not like a personal injury case where there may be 33% of damages to multiple millions of dollars in a car wreck or something like that. So they're normally pro bono attorneys, legal aid societies, things like that. And routinely, when these provisions are violated, they tend to be attorney mistakes, much like SPAR was an attorney mistake. Chopra ended up being an attorney mistake. Joran's actually an attorney mistake. And that's why the other reason we wanted this in from a policy standpoint was so the attorneys could read it directly in the statute. They didn't have to go looking for it. Because trust me, I've been there. I made this comment the other day to somebody about a different bill that had a legal review requirement of some documents. And I said, well, the interesting part about that when you relate to unemployment is I said, our staff that live unemployment every day tend to be more knowledgeable of the actual UI laws than the entire state bar, save and except probably 1 out of 10 attorneys, and that 1 out of 10 attorney tends to work for us, whether it's our current attorney, a former attorney, someone like that. So putting this out there is for all parties, and that includes the judges.
So I think you said on one of the cases, I don't remember which one, you said that somebody missed a party or didn't list a party, right? So
That was on auto, sir. Yes, Troy Jordan for the record.
So the administrator is always a party because they're the adjudicator, if you will. And then you have an employer and an employee generally. But there may be several employees, so there may be like 10 parties that are on this, or is it more narrow than that? In other words, how did they miss a party?
Auto was not an unemployment case. It was an Administrative Procedures Act case, but it applied across the board to all administrative procedural law. And in that case, it was a tax case out of Washoe County, and they had multiple parties, and the deputy DA who was filing the appeal did not name all the taxpayers. In our case, the only parties they would have to name are the employer and the administrator.
Every taxpayer in the county, or what?
It wasn't every taxpayer in the county, but I believe it was, don't quote me on the number, but I believe it was like 10 different taxpayers. It was one particular district of homes, and he didn't name the appropriate parties, and it got dismissed.
Well, I'm just trying, the reason I'm asking, and hopefully this will bring it clear, because I know, so what are the ways that a person can be served? So is it Nevada Rules of Civil Procedure, is the mailbox rule, I know you mentioned that, does that work? People are doing service or trying to do service. You have the traditional way where you send a marshal or a constable or somebody out to serve. But people can hide and evade service for 45 days and apparently win their case under this.
Oh, okay. The only, Troy Jordan for the record again. In unemployment cases, it's a little bit different in this sense, is that they can serve the administrator, and as long as they maintain enough copies, we serve the other parties. And once they've served the administrator at Dieter, at the building, that is considered served for all parties. With regard to other regular forms of service, you're right. You can do the normal constable thing. You can have your buddy walk in as long as they're over 18 and they're not a party to the lawsuit. But the other thing is the Supreme Court in DeRosa, which was an attorney general case on a different Administrative Procedures Act case, has issued a thing that says they can mail it. And we get most of our service either in person at the building or we get it through the mail. And that's why Joran became an issue, was it was a mailbox rule case, was they mailed it late, thinking they had the mailbox rule, and the court ruled otherwise. But there's another issue in there in Joran that's not exactly that clear cut, but it basically showed that the mailbox rule didn't apply to this statute. But there are multiple ways to do that. And the other thing about the unemployment statute that is different than others is there's actually a ban on them paying fees for the filings or being charged fees by a court. So they have the right to do this all pro bono, informis pauperis, so that this is all available to them at court expense.
So if it's an unemployment case, service to the administrator, if I only sent 4 copies and there were 5 people, I'm going to be deficient. If I sent you 15 copies and there were only 10, I'm going to be okay. I'm just trying to, whenever I look at something, it's like all of this stuff, I look and say, okay, here's the rule. How would somebody mess with, how would you be able to game it? And have we covered all the bases? In other words, people can evade service or hide in various things. Try evicting somebody in California, and you actually have to give it to them. You can't tape it to the door, and if they just never do anything with it, it takes months, right? And I can understand you guys wanting to codify what the court said, but when it gets here to the legislature, we can nullify all of those cases by changing the law in whatever direction we think is the best, right? And I'm just trying to make sure that the service is there. You know, why isn't there a good cause like they have in 233B? Maybe we can tighten that up or whatever. I'm just trying to make sure that when you're looking at unemployment, you look at workman's comp, there's all of these steps that are just like rigid. And if you miss it, you can have the most valid claim in the world, but you're going to lose because you didn't follow some little procedure. And I think that's frustrating for a lot of people, especially if they don't know. I understand we can't go on forever, but at the same time, just having that end of the road, sorry, sucks to be you, sorry for your bad luck. I don't know if we want to be there. Thank you.
Do we have any other questions? Okay. Not seeing any further questions. Thank you so much. And we will have you step back from the table and we will open up testimony in support of Assembly Bill number 12. I don't see anyone in Las Vegas, and I don't see anyone rushing the table here in Carson City, so we are going to move to the phone lines broadcast. Is there anyone on the phones who'd like to testify in support of AB 12?
If you would like to testify in support of Assembly Bill 12, please press star 9 now to take your place in the queue. Chair, your public line is open and working, but you have no callers at this time.
All right. Thank you so much, broadcast. With that, we will move to testimony in opposition of Assembly Bill 12. And not seeing anyone coming to the table here or in Las Vegas, we will head back to you for the phone lines broadcast. And thank you.
Chair, your public line is open and working, but you have no callers at this time.
Okay, and that brings us to neutral. Do we have anyone who'd like to testify in neutral on Assembly Bill 12? Not seeing anyone in our physical locations, broadcast back to you.
Chair, you have no callers at this time.
All right, would you like to make any closing statements on Assembly Bill 12? Okay, with that, we will close the hearing on Assembly Bill 12, and we will open the hearing on Assembly Bill 21, revising provisions relating to unemployment compensation, and we will welcome some of our same players back to the table. Thank you so much.
For the record, Chris Sewell, Director of Dieter. A couple of same players, one new player, our chief economist for Dieter, who I think you all know is Dave Schmidt. This is actually a formula in statute that we would like removed. So there's a lot of math here, and I think Dave is probably the best person to explain this because he runs basically has to live this every single day. So I'm going to turn that over to our chief economist, Dave Schmidt, for further explanation on what AB 21 will provide.
Thank you, Director. My name is David Schmidt. I'm the Chief Economist for the Research and Analysis Bureau in Dieter. We're picking up on page 9 of the presentation. AB 21 has a couple of largely unrelated provisions, so we're going to start taking a look at Section 1. Section 1 repeals some definitions in NRS 612.550 subsection 1, as well as some elements of subsection 7. This is looking at trust fund solvency. And when we use the word solvency in this context, we're talking about, do we have enough money to pay for unemployment benefits in a future recession? It does not mean like insolvent as far as $0, but rather enough dollars. And essentially the recommendation for section 1 of this bill is to eliminate subsection 7 of NRS 612.550 and then cleaning up the definitions that are related to that formula. Turning to slide 10, the formula that currently exists in statute essentially says how much money might you need to pay benefits in a recession looking at your worst experience of the last 10 years. This formula has no actual impact. It just says do the calculation on September 30th. And that's it. It doesn't say who should look at it, who you should present it to, what should happen as a result, because this formula used to be tied to a solvency tax that would be applied to employers if the reserves were below this level. That was repealed with SB 340 in the 1983 legislative session, and ever since then, this formula has just kind of lived on. Looking at slide 11, the problem with this is, as I said, this formula is too volatile. 10 years is not a very long period. We've had several economic expansions that go for more than 10 years. And so this formula, because it only looks at 10 years, will start to drop the recommended benefit level if you move more than 10 years past a recession. Obviously, just because it's been 10 years since the last recession does not mean that you won't have another one in the future. And so the short memory of this formula is a problem. It also is too volatile. In the COVID recession, we paid out about $2.5 billion in benefits, but because of the way this formula is structured, the recommendation that it would have for us today is to say, actually, you need $8 billion in the trust fund. That is kind of an absurdly high number, and while we don't have to do anything with this formula today, I've been here 20 years, and so I know that this formula can be too volatile, and we can just say, let's just ignore it. But I won't be here someday, and I would not want a formula that exists in statute to guide bad decisions. And so that's essentially the impetus for cleaning this up. Slide 12. If this formula went away, well, in practice, we already use a different formula. There's a similar sort of measure that's recommended by the federal government. It looks back 20 years, or a period of time long enough to include at least 3 recessions. And so it has a longer memory, and it averages your 3 worst years instead of looking at particular points in time and multiplying them all together. Prior to COVID, the formula worked pretty well in statute. It wasn't my favorite, but it didn't give you anything unreasonable. COVID was so extreme that you end up multiplying things together that can't actually happen at the same time, but it sort of reinforces the worst elements that it has, which is why it's too volatile. So this federal measure looks back over 3 years, or 3 recessions or 20 years. It averages the results over 3 years, and it's something that we look at nationally. To be clear, this bill does not implement this solvency standard, but this is just what we already use anyway. And so if the question is, well, how would you know if you have enough money? We would just sort of do it through analysis, but not through something that's codified in statute. Slide 13 looks at the details here. In blue, you have the calculation as it's been done through the last several years. As I mentioned before, in 2018, the formula recommended a balance of $1.5 billion. In 2019, that fell to $1.2 billion because we were moving more than 10 years past the Great Recession. By 2021, it was at $4.8 billion, and our estimate that for the calculation as it's done this year would be at $8.2 billion. So just so you can see, in a period of 7 years, we've gone from $1.2 billion to $8 billion. It's recommending that we hold in reserves more than double what we paid out during COVID, which was by far the most extreme thing that we've ever experienced as a state. It's because it only looks at your worst single experience in the last 10 years, it will tend to overreact. But say we get to 2030 and 2031. Suddenly it would forget that COVID ever happened and just drop that number like a stone. It would cut by about 80 to 90% the recommended balance. So if you were following this formula, you would build up massive reserves and say, what are we supposed to do with it? So I think I've hit the point hard enough. The formula, I think, should just be eliminated from statute. That's what Section 1 of AB 21 would accomplish. Section 2, turning to slide 14, is a different matter entirely. It looks at money coming into the Unemployment Compensation Administration Fund, or what we usually refer to as the Career Enhancement Program, or CEP. And essentially, the bill does one thing. The CEP tax, when it was implemented, employers, the rates payable by employers to the Unemployment Compensation Program were all reduced by the same amount, which is 0.05% of the taxable wages that employers pay. The idea, I think, being we will reduce this tax rate, we will increase this other tax rate to provide workforce services. If you don't spend that money to provide workforce services, that money flows back to the trust fund. In practice, the way that this statute outlines it, and you can see this on slide 15, employers pay taxes on unemployment benefits as well as for the CEP program on the first certain amount of each employee's wages. That number is currently about $40,000. Once you've moved past that amount in a calendar year, further wages are not subject to the unemployment or CEP tax. This tends to front load the revenue collections based on the first calendar quarter, which are collected in the second calendar quarter as employers file their reports. And so at the end of April, beginning of May is when employers' reports for that first quarter are due. And so the largest share of our revenue for both unemployment and the CEP program come in April and May. When wages are rising more rapidly, this will increase that concentration of revenue that's early. But CEP revenue has to revert to the Unemployment Trust Fund for the unencumbered balance for the upcoming fiscal year after 90-day period. And so if we have an upside surprise in revenue for these workforce programs, there's a very limited time to plan, go through the purchasing and contracting process, and effectively spend that money before it has to be reverted. And so essentially what ends up happening if there's more money is push more into the things that are already established so that it doesn't flow back to the trust fund, because we have about $2 billion in the trust fund. $100,000 or $1 million, the sorts of numbers that you might see in the CEP program are very small potatoes to the Unemployment Trust Fund. But they can provide very meaningful services to people who are getting those workforce services dollars spent on them. $1,000 means a lot there, and it's beyond a rounding error for the trust fund. And so the solution in this bill is not to say, well, you don't have to revert it ever, because the goal is also to make sure that the money hits the streets. And so instead, Section 2 of AB 21 proposes changing the 90-day period that you have to obligate that money to 180 days. It gives you an extra 3 months to plan, to go through the contracting process and try to find the most appropriate ways to spend that money. It doesn't let you build up a slush fund. It doesn't let you just hold on to the money. It still reverts it, but it gives you a little bit more time to plan. And that's, in essence, what Section 2 of AB 21 accomplishes. With that, I'd be happy to take any questions.
Senator Ellison.
Thank you, Madam Chair, and thank you guys for the presentation. I just have one. During COVID, when you're talking about COVID, weren't the state receiving grant money back at that point in time that helped offset that?
Thank you, Senator David Schmidt, for the record. All of the federal programs that were built in COVID, there were a few different varieties. One was the PUA program, which was a separate benefit program for self-employed or gig workers outside of the normal structure of the unemployment program. That was entirely federally funded. That's not what we're talking about here. There were also federally paid extended benefits, but those applied after someone had received their normal unemployment claim. So someone who filed in March of 2020 would have received their up to 6 months of regular unemployment benefits and then transitioned into those federally paid extended benefits to provide them with extra weeks. So there was a lot of federal funds there, but there was also that initial component of state dollars. And because so many people were affected very quickly, the state's unemployment rate got up to 30%, there was a large outlay from March to December, which then shrank a lot as people moved on into those federal benefits.
Senator Steinbeck.
Thank you, Madam Chair. So on the first section you were talking about, in absence of that formula, what will you use to determine an appropriate fund balance?
David Schmidt for the record. What we do already and what we would plan to continue to do is use the federal average high cost multiple. Essentially, it looks at your benefit outlays as a share of your total wages. And then uses that to say, do you have sufficient money? The main difference is the nature of the formula is a little different. And it looks at a 20-year period or a period of time long enough to include 3 recessions. And it averages your 3 worst years instead of just looking at your single worst year.
Okay, so you use that now?
That's correct, Senator.
Okay, so you're not using the formula that we're trying to get taken out?
That's correct, Senator. We do the calculation. We present it because it seems like
Please go ahead and share your name for the record, just so we make sure it's on file. Thank you.
Yes, David Schmidt for the record. So yes, we do that formula. We do it because it's in statute and we present it. Nothing actually says we have to, but it seems like it's appropriate. But we also present this other multiple, and you would see it in the documents that we present to the Employment Security Council and in the rate setting process to say, here's the recommendation that we would suggest is most appropriate.
All right, thank you. Thank you, Madam Chair.
Do we have any further questions? Okay. Not seeing any further questions right now. Oh, if you want to make a comment, please go ahead.
Sorry, Madam Chairman. Thank you for the time. Troy Jordan, Deputy Director again. I've been tasked by the Director. That's why I jumped in. An issue actually has arisen recently that we're going to add a 3rd section of this bill, and I realize that you have no amendment in front of you. I realize that we did not get that done on time, but it arose recently. It is our intent to have we'll call it a conceptual amendment today, but we're going to add 1 section to the bill relating to IRS Publication 1075 and a recent ruling from the IRS of how that is interpreted. Our fraud team is required to have background checks done every 5 years in order to access the IRS system for certain fraud cross matches. It has recently been ruled upon that the DPS here at the state cannot give us those FBI background checks without actual statutory authorization, so we are adding a section to the bill that simply gives DPS the statutory authorization to allow those background checks from Dieter. And again, we apologize for not having that done earlier today, and to you. and I'm happy to take any questions if there are questions from the panel.
Senator Scheibel.
Thank you. Will the amendment include enrollment in a RAP-back program?
Say that again?
Will the amendment include enrollment in a RAP-back program?
Not that I'm aware of. It was my understanding that they simply cannot perform the background check program without the authorization, so I can look into that issue for you.
Okay, that is also my understanding, that they need authorization to provide background checks or fingerprints to anybody. I just want to make sure that we're not expanding the amendment beyond only allowing them that authority.
Troy Jordan, for the record, since I violated that for the 5th time today, through the chairman to the senator's question. Our intent, this was actually recommended to us by DPS that we put this in a bill, and this was the bill we thought we could amend because it was germane, because it's in the chapter, and it was a bill that was mostly simple. So we will have them write that. I will make sure that DPS is involved, and we make sure we get it right when we get the language.
Thank you.
Okay. Thank you so much, and thank you for sharing. And once you have the amendment, please do share that with us so that I can make sure the entire committee gets it. And Senator Flores, I believe, has a question.
When was that recommendation made for the new amendment?
The recommendation to us was made a while ago. We thought it was coming out in a different bill. When that didn't meet the deadline, we were asked to get it in our bill.
Understood. And then just one final follow-up. Have you been conducting these background checks already and then
Yes.
realized you were not in compliance?
Well, what we realized is they have to be done
And
every
Mr.
5.
Jordan, give us your
Sorry.
name for the record.
Roy Jordan, Deputy Director for the record, for the 6th time today, sorry. To Senator Flores' question through the chair, the way we found out about it initially was they have to be renewed every 5 years, and some people came up for renewal, and because of the change in the federal interpretation, they said they could no longer do the background checks for us. So it's been done every year. This is the first set of people where we're not out of compliance yet, but we're going to get there if we don't change the law.
Appreciate it. Thank you, Madam Chair.
Okay, thank you so much. And again, when you have that amendment, get it in our hands, and I'll make sure the entire committee has it.
Thank you.
All right, and with that, we'll have you step back from the table, not seeing any further questions, and we will take testimony in support of Assembly Bill 21. We'll start in our physical locations and then move to the phones.
Good morning, Madam Chair, members of the committee. Paul Moratkin with the Vegas Chamber. The Chamber is in support of AB 21. We appreciate Dieter wanting to modernize this part of the NRS regarding the formula. As you heard, it's not been used, and we believe that the existing formula they're currently using, the 20 years, is more fair to employers and to the system. And it also does not jeopardize the solvency of the fund with this update. So we appreciate their efforts to modernize, and we are in support of the bill. Thank you, Madam Chair, members of the committee.
Good morning, Madam Chair, members of the committee. For the record, Andrew McKay, Executive Director with the Nevada Franchise Auto Dealers Association. Just to echo the comments made by Mr. Moratkin, we obviously support this bill. Addressing the volatility of the current formula that is in statute, obviously that's that's important. And when you look in terms of what the feds do over a 20-year period, less volatility means more predictability, quite honestly, for businesses, and honestly does nothing to jeopardize, the solvency of the trust fund, and this is obviously a modernization step that we fully support. So thank you for your time, Madam Chair, and members of the committee. You guys have a great couple deadline days. Good luck to you.
Thank you. We may need it. All right. I don't see anyone else to testify in support here in Carson City, and I don't see anyone in the room in entirety in Las Vegas, so we are going to move to broadcast. Is there anyone on the phones who'd like to testify in support of AB 21?
Chair, your public line is open and working, but you have no callers at this time.
Thank you so much. With that, we will move to testimony in opposition of Assembly Bill 21. And seeing no one approaching our tables, we are going to hand it back to you, broadcast. Anyone to testify in opposition?
Your public line is open and working, but you have no callers at this time.
Thank you so much. And with that, we are going to head to neutral on Assembly Bill 21. And not seeing anyone at the tables, broadcast back to you. Anyone on the lines?
Chair, you have no callers at this time.
Thank you so much. Would you like to make any closing statements on Assembly Bill 21? All right, seeing no closing statements, we will close the hearing on Assembly Bill 21, and we'll move to the final portion of our agenda, which is public comment. Anyone who'd like to make public comment, we would ask to come up to the tables. We do ask that you clearly state and spell your name for the record, and we look forward to hearing from you. Anyone in Carson City? Anyone in Las Vegas? Anyone on the phones broadcast who'd like to make public comment?
Chair, your public line is open and working, but you have no callers at this time.
Thank you so much. And with that, just a notice to everyone, we will not be meeting on Wednesday. We will, however, revert to our original time on Friday morning at 8 a.m., where we'll be conducting a number of hearings. We look forward to seeing you then. And with that, we are adjourned.